So finally, it's time for some good news. We're really thrilled to open the 2024 Columbia Global Freedom of Expression Prize ceremony to celebrate legal decisions and legal services worldwide that strengthen freedom of expression. But before we get started, we're just going to reflect for a moment on some ongoing challenges. Preparing for tonight, I looked back over previous years to get a sense of the trends. In 2014, the leading concerns were violence against journalists, government surveillance, and censorship. Over the next years, those issues continued to escalate. In 2018, a major challenge was the rise of authoritarian leaders, jurisdictional clashes over technology, and increasing restrictions on freedom of expression. Regrettably, we've seen limited progress in these areas. Our co-founder, Agnes Callamard, has long argued that many of these negative trends are the result of the disintegration of the post-World War II rules-based international human rights system. Agnes has written that we cannot respond effectively unless we take stock of these global norms, values, and systems, and what they have achieved. Today's conversations have sought to explore how far we have come over the last decade and identify where we need to focus our efforts going forward. The power of these norms is based on the conviction that they are universal, inalienable, indivisible, and interdependent. In a recent Foreign Affairs article, Agnes wrote, and I quote directly, "The fate of universality resides not in the hands of those who betray it. Rather, it is a perennial, ambitious project for humankind. Its power rests, first and foremost, in its continual proclamation and in its persistent defense." Tonight, we recognize those who continue to proclaim and defend those rights in the face of increasing pressure and odds. The prizes have sought to recognize novel and influential court decisions and those whose legal services have made them possible. The first Global Freedom of Expression Prize back in 2015 went to Peter Norlander and Nani Jansen Reventlow, then of Media Defense, for their litigation in Keynote v. Burkina Faso before the African Court on Human and People's Rights, a case we heard about earlier today. And it set important standards for the decriminalization of defamation in African states. Media Defense has continued their path-breaking work and was nominated again this year for their advocacy combating internet shutdowns in more than 5 court cases. In 2016, the Legal Services Prize went to Yaman Akdenis, Karim Altiparmak, and Sergan Cengiz for their successful action before the European Court of Human Rights challenging website blocking in Turkey. Professor Akdenis was once again nominated in this round for his continued advocacy to end internet censorship. Solomon Okudara of Nigeria has also been nominated twice for challenging cybercrime laws in Nigeria. Litigation often takes years and is costly, but the determination of our prize nominees and the response of principled courts will help preserve the international system. This year, we were gratified to review an impressive array of 62 prize nominations spanning 27 jurisdictions globally, with contributions from diverse nations, including Armenia, Togo, Paraguay, the Philippines, India, and Slovakia, among others. The breadth of issues addressed in these nominations was particularly noteworthy, encompassing critical areas of freedom of expression, such as whistleblower protections, the use of facial recognition technology, online gender-based violence, access to information amid the COVID-19 pandemic, and the essential connection between freedom of expression and the right to education. These nominations reflect the complex and evolving landscape of free expression across the world. Many of the nominations were groundbreaking, making the selection process extremely challenging for the members of the prize committee. We have highlighted some of these decisions in our weekly newsletter for our followers to appreciate the diversity and significance of these rulings. While there can only be 2 winners, the collective nominations are an important barometer for the strength of judicial protection for freedom of expression. They provide a source of hope and inspiration by showcasing the ongoing efforts to uphold and advance free speech globally. So tonight we're going to have a very special guest and performance by Viva Quintana, and I believe she is not yet here. So we are going to move on, and I am going to introduce our keynote speaker, Elena Kostyuchenko. Elena, if you were here earlier today, you got to hear the amazing book talk, but Elena is one of Russia's most talented and fearless reporters who spent 17 years at Novaya Gazeta, the country's last major independent newspaper that was shut down in March of 2022. At Novaya Gazeta, Elena covered Russia beyond Moscow and the Kremlin, telling stories of ordinary and marginalized people. In the first days of Russia's full-scale invasion of Ukraine, Elena crossed the border to cover the war, recording the horrors of the Russian army that the horrors Russian army was committing. She knew the publication of her reportages would likely lead to her being prosecuted by Russian authorities and potentially facing up to 15 years in prison. Elena has survived 2 attacks from the Russian government for her reporting. Still, she refuses to be silenced and continues to write. It is an honor to have her here this evening, and Elena, the floor is yours.
Thank you so much. So, I'm a journalist, and all I'm doing is writing and talking to people. And recently, I was filling out a questionnaire and had to dredge my memory for all my run-ins with the law. Honestly, I've lost count of how many times I've been detained by police. More than 20, I think. Sometimes it's just meant to be stuck in a cage for an hour, but I had policemen spit at me, beat me up on the occasion, and once show me down a flight of stairs. One time they turned some ligaments in my neck, and that was a miracle that I escaped being paralyzed. From the police cell, I'd go straight to court. Every time, except a single one, I ended up being convicted. I remember the judge who ruled that my work did not constitute a crime and exonerated me. He served in a small town called Khimki. There, all the power rested in the hands of few corrupt who committed crimes against the town's citizens. I was investigating those crimes. My work displeased Khimki's rulers, who thought they had control on the municipal court. But this judge chose to let me go. My freedom was his choice. I'm so lucky to be able to speak here, and especially now. On April 18, more than 100 Columbia University students and staff members were arrested during a peaceful protest. It was the university president, Niemand Minus Shafik, who called the police. If I studied or worked there, I would stand beside the protesting students now. Not because I agree with their opinion, but because I know what happens when you don't defend another's opinion. The day after, you yourself won't be able to speak up. Our rights are not a given, they are a process. They change every day. Decisions we make today will govern our lives tomorrow. No one should be detained for protesting peacefully. No one should be detained for their opinion. If we cross this line, we find it very difficult to repair. The price could be many human lives. It isn't a question of who is wrong and who is right. It isn't a question on what is happening between Palestine and Israel and whose pain is the greater. Repression is never the answer. Repressions are born of fear. Fear makes things that have not had happen real. You feel the danger growing close. It seems that it's all right to compromise a bit, to quieten your principles, if only in exceptional circumstances. Yet, when we compromise our principles, trampling human rights, we are the ones creating exceptional circumstances. The history of my country is clear on this. Then, in 1993, the democratically elected president, Boris Yeltsin, attempted to dissolve the communist parliament in contravention of constitution and then fired on the parliament from tanks. Many supported his actions. They were afraid of a resurgence of Soviet Union with its repression, censorship, violence, war, unfair election. Yeltsin handed power to Putin, and violence toward political opponents became the norm. We have no parliament now, no freedom of speech, no election. We have war, repression, censorship. The compromise led us straight to what we feared. 6 of my colleagues of Novaya Gazeta were murdered. The newspaper itself lost its license. It carries on, but illegally. Most of its staff are in exile. I lost my home too. When you invite police to your campus, you open the door into another reality. To shut this door again requires huge, long-term effort. Perhaps the effort of the next generation too, the one you were trying to protect. Freedom of expression is a fragile thing. Freedom of expression requires vigilant protecting. Freedom of expression demands faith in people, and that's the hardest part. It's hard to speak when you are hurting. It's even harder to listen. It's so hard to really listen rather than just wait for your turn to make your argument. But conversation is the only thing that can keep the peace and stop the war. Freedom of expression is a thing beyond price. Please don't underestimate it, exchanging for a silence in the campus. Thank you so much. Should we keep going?
Yes, I think we'll move on. We will have Alejandra.
Okay. So we will now confer the 2024 Columbia Global Freedom of Expression Prize. Juan Montel will present the prize for significant legal ruling category. Juan Manuel Espina is a legal researcher with Columbia Global Freedom of Expression, who lead the processing of the prize nominations received for the significant legal ruling category. He received his law degree from the Universidad de los Andes in Colombia. There he has also obtained a master's degree in journalism. He served as chief editor of El Uniandino, a leading college newspaper from Bogota, Colombia, and he has taught university-level classes. Welcome.
Thank you very much, Elena, for your introduction. Good afternoon. On behalf of the Selection Committee, it is my great pleasure to present the Columbia Freedom of Expression Prize 2024 in the category of Best Legal Ruling. This year's prize recipient is the High Court of South Africa, Johannesburg, for the Mazetti Management Services and another versus AmaBhungane Center for Investigative Journalism and Others ruling. In this groundbreaking decision, the High Court of South Africa issued a judgment that advances legal norms on freedom of expression in a way that fosters democracy and the rule of law. By refusing to yield to powerful corporate interests and siding with journalists investigated corruption in Africa, the court vigorously protected press freedom. Amidst a myriad of excellent nominated decisions that the prize committee analyzed, the Mazetti ruling stood out for several reasons. In this exceptional case, the court set an outstanding precedent that is protective of investigative journalism, sources protection, and the right of South Africans to access information on matters of public interest. such as transnational corruption. Judge Sutherland's arguments throughout his decision also outline important considerations that are worthy of imitation when it comes to SLAPs and their detrimental effects on democratic participation, an issue that, as we have discussed today, has become a top priority. With rigor and courageousness, the court judgment extended protection to the South African media outlet AmaBhungane Center for Investigative Journalism, from baleful attempts to abuse the judicial system. In doing so, the court also provided an essential backing to journalists and sources around the world, recognizing their vital work for strengthening civic participation in democratic societies. At this juncture, one where press freedom is under constant siege from forces seeking to erode its role as a public watchdog, brave decisions, such as the one issued by the High Court of South Africa, need to be celebrated, for they are exemplary in their protection of much-needed democratic values. We are now going to show a short video by Jake Price about the prize.
On July 3, 2023, the South African High Court handed down a landmark judgment. The court's considerations regarding the positive civic role of investigative journalism and its methods to combat corruption laid out a positive framework protective of press freedom. Despite the fact that 1996 Constitution protects press freedom, being an investigative journalist in South Africa is not an easy task.
It's a privilege and a curse. It's a privilege because we have a democracy, we have legal protection, but it's a curse because there's a lot wrong. The country is virtually broken.
I would say daunting, because there are so few of us and so much work to be done.
I would say it's inspiring and necessary. And inspiring because I know firsthand the risks that journalists face. The work that investigative journalists do is sometimes what feels like it's the only thing holding the country together.
In February 2023, the AmaBhungane Center for Investigative Journalism published 3 articles critical of the business activities of the Moti Group in Zimbabwe and South Africa. Some of the claims were based on information provided by an anonymous whistleblower. The Moti Group used legal actions, including obtaining an order requiring that the AmaBhungane return any digital documents obtained by an internal leak.
This was a case about source protection, and it was a case about the right to make use of leaks. It was also a slap case, in the sense that the protagonist who we were writing about used both the courts and, in fact, social media to launch a concerted campaign against us. There were quite significant personal attacks on my history and character, shall we say.
And simultaneously, he hired a PR firm to produce, quite slick videos that were constantly made available on the internet, attacking, like you said, Sam.
And then there was the sort of use of some of his supporters to also start attacking us on social media and broadly by issuing press statements criticizing the work that we were doing. And then the final prong was the legal prong. And that also sort of came about with a threat of potential criminal action against us, and then obviously the civil action that did get followed through.
AmaBhungane brought an urgent motion for reconsideration. Thus, the question before the High Court was posed whether it is intrinsically unlawful for journalists to receive, retain, and preserve leaked information and to publish it in the public interest.
We have legislation that gives effect to the right to access information, and we have a very strong judiciary that steps in when perhaps those laws aren't given effect to or aren't implemented properly.
The legal framework is strong. The respect for that legal framework diminishing, I think, from a number of quarters, both from government and from other players.
It was not certain what the court would decide. The court decision was clear. The court established a precedent highlighting the danger of private companies bringing extensive litigation against media outlets and stressed that the courts cannot tolerate abuse of process. The court also emphasized the importance of maintaining sources' confidentiality and that the rights to privacy can be limited when publication of private information is in the public interest.
We have the right to privacy as well as the right to freedom of expression. And this was a big test, potentially, of the balance between those two. And the judgment came down very clearly, and quite succinctly and unarguably on the right of the media to penetrate some of that veil in the public interest.
This decision is exceptional because it advances freedom of expression on multiple levels. Firstly, it identifies the litigation against AmaBhungane as an abuse of process and introduces criteria for understanding SLAPs. Additionally, it emphasizes safeguarding anonymous sources crucial to investigative journalism and highlights the significance of protecting whistleblowers. Finally, the departure from precedent regarding corporate confidentiality enhances press freedom, particularly in matters of public interest.
What was really important about this judgment was that it was taking that strong jurisprudential tradition of protection of the media and applying it to the realities of a very online and technological world that we as journalists are operating in.
I think also there's an element of exceptionality in that it counted what was an exceptional attempt on his part to essentially criminalize leaks, to say that the leaking of information is criminal, or the use of the information from the leak is criminal, which is obviously a devastating notion for journalism everywhere in the world.
It was certainly a great relief when it happened, I think it does strengthen our hand. But I think the way in which it also confirmed the protection of whistleblowers and the right to protect their anonymity where appropriate. That's important for some of these struggles going forward.
It is my great honor now to give the floor to South African lawyer Caroline James, who has been the advocacy coordinator for the AmaBhungane Center for Investigative Journalism. Thank you very much for being here, Caroline.
It is an honor to be here representing one of the parties to the case, the AmaBhungane Center for Investigative Journalism. For us, this case represented the multiple threats to investigative journalism in South Africa, and it brought home that the repression of freedom of expression is definitely not abstract, something that is unfortunately clear here today as well. We often talk about the principles of the right to freedom of expression in the South African Constitution and in international law, but for a while, for AmaBhungane last year, we feared that those principles may not practically serve to protect us. Because for those principles to be enjoyed, they have to be given practical effect to. They must be applied in the face of financial, political, or social pressure, and when the prevailing winds in a society appear to be blowing against them. Last year, it felt that our ability to do our jobs as investigative journalists was being attacked from all sides. There were threats of criminal charges and physical harm, and the order that had been initially obtained by the Moti Group shocked us deeply. Here, in democratic South Africa, a court had ordered journalists to reveal sources and gagged them from publishing stories critical of a powerful and rich businessman. AmaBhungane journalists have faced many challenges in their history, not least the risks associated with exposing the state capture corruption of our previous president, Jacob Zuma. But last year marked a new stage in the fight for investigative journalism in South Africa. The case came at a time when colleagues in other media houses were facing similar but distinct challenges. One journalist was facing a private criminal prosecution brought by Zuma, and a news website was fighting an interdict application brought by businessmen unhappy at a term used to describe them amid vague threats of defamation. This trilogy of cases served to highlight the myriad threats and the necessary, but in some ways unfortunate, reliance on the judiciary for journalists' protection. But one of the most notable features about the AmaBhungane judgment is how Judge Sutherland actively applied the constitutional principles protecting media freedom. He did not technically have to discuss freedom of expression at all. The legal finding of his judgment was that the order had been obtained against AmaBhungane was an abuse of process, a technical finding that turned on the fact that correct procedure had not been followed by denying AmaBhungane an opportunity to be heard. But the judge then spent more than half the judgment discussing the substantive issues that AmaBhungane had raised about the impact of the initial order on media freedom. Had he stopped at the procedural aspect, the surface level effect may have been the same. The initial order would have been overturned, and AmaBhungane would have been able to resume publishing. But that would not have enhanced protection for media freedom on a far greater level in South Africa. This can be seen in the fact that the judge in one of the other contemporaneous cases referred directly to the AmaBhungane case. That case cited Judge Sutherland's statement that a South African court shall not shut the mouth of the media unless the fact-specific circumstances convincingly demonstrate that the public interest is not served by such publication. Going beyond the merely technical aspects meant that the Johannesburg High Court powerfully restated what the exercise of freedom of expression means in practice. It restated principles and reapplied them to new circumstances, in stressing that journalists have the right to receive and possess leaked electronic information and cannot be forced to reveal a source, and that there are only extremely narrow circumstances in which journalistic stories can be gagged pre-publication. It is only because the judgment addressed the free speech issues that the true threats to media freedom that the initial order had posed could be countered. And then the breadth of Judge Sutherland's judgment allowed another judge, faced with a different kind of threat to journalism, to further entrench the active enjoyment of the principles of freedom of expression. The AmaBhungane judgment teaches us that realizing the right to freedom of expression requires an active defense of the right. It shows that the rights themselves mean very little without the work done to apply them to the challenges and threats of our specific circumstances. It is easy to flaunt adherence to human rights principles when times are easy, but it takes far greater courage to do so when the pressure against them seems almost overwhelming. And this is also why events like tonight are so important. To know that all around the world, lawyers, activists, journalists, and citizens are actively working to ensure the realization of the right to freedom of expression is what will encourage more of us to follow their lead. Thank you.
Good afternoon, everyone. I have the honor to present Vivir Quintana. Vivir Quintana is a Mexican singer, songwriter, specializing in rhythms such as the new Latin American song, ranchero, and folk. Composer, normalista, and women's rights activist, Vivir is considered one of the most powerful voices of the continent, thanks to her extensive musical work, which highlights Canción Sin Miedo, a song that has been covered and translated in many parts of the world, given its vital theme, denouncing systematic violence against women. A former student of the Escuela Normal Superior of the state of Coahuila, Vivir Quintana was part of the second generation of the composition workshop of the Society of Authors and Composers of Mexico, where she developed her own compositions. In addition, she has been awarded the Maria Greber Scholarship, beneficiary of the Stimulus for Artistic Creation, winner of the Fonca Scholarship for Young Creators, and winner of the Éxito Sociedad de Autores y Compositores de México 2021 award. In the category of Best Independent Song, she was named by Forbes magazine as one of the most creative people in Mexico. She has shared the stage with artists such as Mon Laferte, André Echeverry, El Palomar, Paz Kurt, Manuel García, Aterciopelados, La Marisol, Rubén Albarrán, Leticia Servín, Torreblanca, Carmen Ruiz, entre otros. Vivir has also ventured into film, making music for films such as La Boda de la Abuela, Noche de Fuego, Amalia en Otoño, Las Tres Muertes de Marisela Escobedo, and Somos Fuego, where she acted as narrator. She is currently promoting her last album, the first to be released by Universal Music Mexico. As part of his work, she recently released her new single, Corazón de Ave. Vivir, gracias por estar aquí, gracias por ser la voz de las mujeres a quienes les quitaron la voz, gracias por validarnos, gracias por regalarnos el himno de nuestras marchas feministas, gracias por ser ese hermoso espejo que refleja la luz de todas las causas que cantas. Es un honor tenerte aquí.
Muchas gracias. Muchas gracias. Buenas tardes. Esta canción que voy a interpretar ahora se llama El corrido de mi novela, de un periodista que fue asesinado en México por contar verdades.
One second.
Sí.
Good evening. This song is about a journalist who was killed in Mexico.
Y yo creo firmemente en la libertad de expresión, creo firmemente en la verdad y creo firmemente en la justicia.
I firmly believe in freedom of expression. I firmly believe in freedom. I firmly believe in truth.
El corrido de mi novela.
El corrido de mil ovejas is the name of the song.
Okay. Se alborotaron las aguas del puerto de Veracruz. Una noticia macabra pintó de rojo su azul. Fue en junio 20 del 11. Sé que te acuerdas bien tú. López Velasco apellido, Miguel Ángel fue de nombre. De aquel gran comunicante que se marchó con honores, porque su vida arrancaron junto a dos de sus amores. Fue de alto riesgo su oficio y con pasión lo ejercía. Para cualquier periodista, qué peligrosa es la vida cuando se dicen verdades. Se esconde la policía. Fue de alto riesgo su oficio y con pasión lo ejercía. Para cualquier periodista, ay, qué jodida es la vida cuando se dicen verdades. Se esconde la policía, sigue la pluma encendida de mi Gabo y Yolanda. A la verdad no se mata, aunque le quiten palabras. ¿Dónde estará la justicia cuando atraviesan las balas? Hay llamas que no se apagan, aunque las quieran callar. Hay velas que son eternas, aunque se las trague el mar, como las de mi Vela, que alumbran la eternidad. Hay llamas que no se apagan, aunque las quieran callar. Hay velas que son eternas, aunque se las trague el mar, como las de mi Vela, que alumbran la eternidad, como las de mi Vela, que siempre dicen verdad. Muchas gracias. Ahorita regreso otra vez.
Alejandro Negrete will present the prize for Excellence in Legal Services category. Alejandro Negrete Moraya has brought years of experience and leadership to Columbia Global Freedom of Expression as this edition's prize manager. She received her law degree from the National Autonomous University of Mexico. She holds a Master's of Art in Legal Argumentation from the University of Alicante, Spain. Throughout her career, Alexandra had worked in the fields of human rights, gender equality, due diligence, freedom of expression, as well as in the making of public policies pertaining to these issues. In Mexico, she served as a national commissioner to prevent and eradicate violence against women and as prosecutor for labor defense in Mexico. Also, she had served as an advisor on human rights for the presidency office in the Mexican Supreme Court of Justice, and as a human rights specialist for the Office of the Special Rapporteur for Freedom of Expression at the Inter-American Commission of Human Rights, the Inter-American Court of Human Rights, and the Inter-American Commission of Women. Welcome.
Thank you very much, Elena. I will speak simultaneously both in English and Spanish, hoping that our message arrives to the Spanish speakers who are in Guatemala. Good afternoon, everyone. Thank you for joining us today as the 2024 Global Freedom of Expression Awards. In an international context in which authoritarianism is on the rise, single views are favored, and dogmas and alternative truths give way to polarization and intolerance, freedom of expression must be vindicated as the way to build more open and democratic societies. That is what this award is about, recognizing the best achievements and progress in this area and reminding us that when freedom of expression is limited, democracy regresses. As coordinator of this edition of the awards, I have the honor of presenting the award in the Excellence in Legal Services category. Como coordinadora de esta edición de los premios, tengo el honor de presentar el premio a la categoría de Excelencia en Servicios Legales. Este premio busca reconocer los mejores logros y avances en materia de libertad de expresión. La defensa y la sentencia obtenida en el caso Pueblos Indígenas Maya Kaqchikel contra Guatemala ha permitido avanzar en el reconocimiento y ejercicio de los derechos de los pueblos indígenas a la libertad de expresión, quienes son la principal riqueza cultural en el mundo. La historia de nuestros pueblos indígenas no puede seguir siendo una de marginación y resistencia, sino una de igualdad, derechos y progreso. El trabajo de nuestros galardonados es un enorme paso en este sentido. After an exhaustive review of the nomination in this category, the selection committee decided to award this recognition to 4 lawyers who have done an extraordinary work in proceedings before the Inter-American Court on Human Rights, which culminate in a landmark judgment from the Inter-American Court in October 2021. Nuestros galardonados son Adriana Sanún and Cristian Otzin, de la Asociación de Abogados Mayas de Guatemala. And Nicole Frederick and Amy Van Sil Chavarro from the Human Rights and Indigenous Peoples Clinic at Suffolk University. Este equipo de profesionales logró que la Corte Interamericana fallara a favor del pueblo indígena maya Kaqchikel y otros pueblos mayas en Guatemala. Mediante esta decisión, la Corte amplió los estándares interamericanos de libertad de expresión al reconocer que el marco regulatorio vigente en el Estado de Guatemala era violatorio de la Convención Americana de Derechos Humanos por considerar que su regulación en materia de asignación de frecuencias radioeléctricas era discriminatoria contra los pueblos indígenas. Based on regional and international standards of freedom of expression in their application, this team of lawyers highlight how this violation of freedom of expression obstructs the ideals of pluralism, democracy, and equality, and how the exercise of freedom of expression was particularly linked to the right to culture, which is fundamental for the survival of indigenous peoples. The solid legal arguments and general theory of the case that they were be able to construct were reflect in the landmark judgment of the Inter-American Court, whose impact is transformative for the entire region. We will see a video about the amazing work of our winners.
The Human Rights and Indigenous Peoples Clinic at Suffolk University and the Association of Maya Lawyers and Notaries in Guatemala have been honored for their exceptional legal services in Maya Kaqchikel, Indigenous Peoples of Sumpango, and others versus Guatemala. Their tireless advocacy before the Inter-American Court on Human Rights led to a landmark decision that challenged discriminatory regulations on radio frequency allocation in Guatemala.
It's the first case that recognizes their right to freedom of expression and ensures that they have access to the radio frequency spectrum to conduct community radio in their country. I think globally, I think it also has significance in that it's the first case that recognizes the right to media as it relates to freedom of expression for Indigenous communities.
In Guatemala, where about half the population is Indigenous and many live in rural areas, radio plays a vital role. It helps Indigenous communities share news and communicate in their languages, preserving their history and culture. It's also a key to protecting Indigenous languages and ensuring they continue to thrive for future generations.
Acá en Guatemala hablamos más de 20 idiomas mayas y cada radio comunitaria que existe se dirige a la población.
Otro de los elementos importantes de la radio comunitaria es que a través de estos medios las comunidades pueden emitir su pensamiento, ¿verdad? Pueden emitir su posicionamiento político también. Y generalmente las radios que han allanado han sido aquellas que están informando a la comunidad sobre una problemática.
In arguing the case, the legal team showed how the Indigenous community's freedom of speech is closely tied to their democratic and cultural rights. These arguments were key to the court's final decision.
Minkone métodos chircone natural, por eso franco mencionar su importancia y el valor chircomadronas para comunidades, ya que la ley SAC no va y la ley como que hacer surta medicina o surta es un buen para que como
Guatemala's General Telecommunication Act provides for a kind of economic process for receiving a license to operate a radio station in Guatemala. Essentially what it does is it conducts an auction, a bidding process. And so we challenge that particular law, saying, look, it's discriminating against Indigenous communities that can't access the radio frequency spectrum, this form of media, to conduct community radio. And the court agreed with us.
Acá en Guatemala existió un conflicto armado desde hace más de 35 años que duró este conflicto armado, y uno de los compromisos que se firmaron en 1996, que fueron los acuerdos de paz, en el inciso H habla especialmente de que el gobierno iba a promover frecuencias de radio para proyectos indígenas y para reconocer dentro del marco legal a las radios comunitarias, y sin embargo estos no avanzaron en ningún momento en el Congreso.
Nosotros nos preparamos con el equipo legal. Iniciamos este caso desde la situación que se daba en Guatemala. De ahí evidenciamos esa discriminación y ese racismo sistemático contenida en las leyes nacionales de Guatemala. A partir de ahí, junto al equipo de Cultural Survivor, así como también la clínica legal de la Universidad de Suffolk, las abogadas de dicha entidad.
In September of 2012, we filed the petition with the American Commission of Human Rights. And then it took about 8 years before the commission decided on the merits of that case in their report and reached out to us in January of 2020 to explore whether the case should be referred to the courts.
Y este caso consideramos que se ganó porque es un primer caso que sentaba un precedente a nivel regional sobre el derecho que tienen los pueblos indígenas a sus medios de comunicación.
The legal teams are now focused on making sure that the court's orders are followed and that Guatemala's laws are changed, confirming their deep dedication to justice, human rights, and freedom of expression.
The court ordered them to also translate it into the languages of the 3 Indigenous communities that were named victims in the case. There were some financial reparations to the victim communities, and that's mostly done.
Los pueblos indígenas no pueden estar excluidos de esta tecnología, del uso de esta herramienta como lo es la radio comunitaria.
Es un medio donde podemos expresarnos las mujeres. Es un medio donde se da a conocer nuestro idioma materno, nuestros valores culturales, nuestra identidad, y también aprendemos sobre nuestros derechos.
A través de su experiencia, dedicación y compromiso inquebrantable con la defensa de los derechos de los pueblos indígenas, nuestros ganadores han demostrado el poder transformador de la incidencia jurídica y la importancia de generar alianzas estratégicas y sinergias entre la academia jurídica y la sociedad civil. Their persevering work serves as an inspiration to us all, reminding us of the profound impact that community and territorial advocacy has in advancing social justice and human rights. Para las personas de las comunidades mayas que nos están viendo, queremos decirles: Nahako Mahari Hebel Isamag Rix Niyararu Kihri Tinamit Ovillayala. Por favor, nuestras ganadoras pueden pasar, tienen la palabra.
Thank you very much. Thank you.
All right, thank you. Before I start my remarks, I just wanted to thank the speakers who shared their stories and insights earlier today. I'm so moved and impressed by all the work that you're... I'm sorry. Sorry. I'm just so moved and impressed with the work that you're all doing. I'm an Indigenous rights lawyer who happened to litigate a freedom of expression case, so it's been really informative being here today. I'm Nicole, and this is Amy. You should come closer, because this is from both of us. Thank you to the Columbia Global Freedom of Expression Program for this recognition. This prize is particularly meaningful given the program's renown worldwide and its promotion of the understanding of this fundamental human right. Sincerely, thank you, and congratulations to your 10-year anniversary. This case is just one chapter of what is now a decades-long movement to secure Indigenous community radio in Guatemala. Indigenous peoples in Guatemala have been marching, have been organizing, lobbying for law reform since the 1990s to allow them to fully access and exercise their right to freedom of expression through community radio. Before and while this case was pending before the Inter-American Human Rights System, several Indigenous communities operating community radio stations were subject to police raids, resulting in the seizure of radio equipment, which then usually meant the closure of these important forums for communities to share and receive information in their own Indigenous languages. On a few occasions, Indigenous community radio station volunteers were even arrested and prosecuted for the, quote, crime of using the radio frequency spectrum without a license, even though there was no viable mechanism to obtain one. The judgment from the Inter-American Court addressed all of this. In a seminal decision, the court interpreted Indigenous peoples' right to freedom of expression as including a right to media, while also recognizing the role that the right to culture plays in the exercise of these rights. It has been the highlight of our professional careers to have learned about this movement from those most intimately involved, and then entrusted to bring this case before the Inter-American Court. We share this prize with those individuals and communities who marched and organized and lobbied Congress, who volunteered at Indigenous community radio stations, often in fear of police action, and with those who lived through a raid, or even worse, were subject to criminal prosecution. International human rights litigation involves lots of people, and this case was no different. I'd like to acknowledge as many as I can before the music starts playing me off. That was a joke. First, the named victim Indigenous communities, the communities of Sumpango, San Miguel Chicaj, Todos Santos, and Cojola, and in particular our witnesses Anselmo Shunik, who you saw in the video, Maria Pedro de Pedro, and Rosendo Pablo. Their testimony before the court was powerful in explaining this important role that community radio plays in their communities and how Guatemala's laws made it virtually impossible to secure a legal license. Our NGO partners, Cultural Survival, an Indigenous-led and US-based Indigenous rights organization, and their sister organization in Guatemala, and Amy, you should just say the name because I'm gonna blotch it.
Asociación Sobrevivencia Cultural.
Thank you. Both these NGOs have been supporting this movement for over 30 years. Sorry, for almost 30 years. I also want to recognize our legal colleagues in Guatemala, Christian and Adriana, with the Association of Maya Lawyers. We have this wonderfully collaborative working relationship, and I want to congratulate you as well. Mention one of our funders, the Impact Fund. They are a U.S. funder of strategic litigation, and they provide financial support to us. Of course, I need to mention Suffolk University Law School, based in Boston, and in particular its clinical program, who has supported the clinic from day one on this case. I also want to make note of our experts, our legal experts in this case. One of them was the UN Special Rapporteur on the Rights of Indigenous Peoples, Francisco Cali, who testified before the court, and Suffolk University law professor Laurie Graham. The court relied both on their testimonies in its decision. Almost done. And because we're a law school clinic, we had the benefit of having more lawyers. It wasn't just the 4 of us. We actually had about 35 law students over the past 12 years who have contributed to this case in one way or another, and they've been really instrumental. And I know I'm up here on behalf of Amy as well, but I need to acknowledge and thank her as a friend, as a colleague. I could have not asked for a better partner in this case. We've been working together since 2012, and it's been such an easy and productive relationship, so I'm happy that we're up here together. And so thank you again to all of you and to all the people I've just mentioned, and thank you to Columbia and its Global Freedom of Expression program for this recognition. It's really appreciated. Your turn. Can I hold it for you?
En nombre de la Asociación de Abogados y Notarios Mayas de Guatemala, así como de mi colega Cristian Otzin, me permito agradecer el reconocimiento que nos han otorgado el día de hoy en la categoría de excelencia en servicios legales.
On behalf of the Association of Mayan Lawyers and Notaries of Guatemala, as well as my colleague Christian Austin, I would like to thank you for the recognition that we have received today in the category of Excellence in Legal Service.
Lo cual representa un reconocimiento al trabajo de acompañamiento jurídico que como Asociación de Abogados Mayas hemos brindado durante estos años a la lucha incansable de los pueblos indígenas en Guatemala y especialmente al movimiento de radios comunitarias indígenas.
Which represent a recognition of the work of legal assistance that we as the Association of Mayan Lawyers have provided over the years to the tireless struggle of the indigenous peoples in Guatemala, and especially to the indigenous community radio movement.
Este premio es significativo no solo para nuestro trabajo, sino porque los logros obtenidos en la sentencia emitida por la Corte Interamericana de Derechos Humanos en el caso Pueblos Indígenas Maya Kaqchikel, Sumpango y otros versus Guatemala no hubiera sido posible sin la lucha incansable que los pueblos indígenas en Guatemala han tenido por más de 2 décadas.
This award is significant not only for our work, but also because the achievements obtained in the judgment issued by the Inter-American Court of Human Rights in the case of Pueblos Indígenas Maya Kaqchikel de Sumpango y otros versus Guatemala will not have been possible without the tireless struggle that the indigenous peoples in Guatemala have had for more than 2 decades.
En donde los pueblos indígenas han demandado al Estado de Guatemala el reconocimiento y el respeto al derecho de libertad de expresión para los pueblos indígenas, derecho que no solo se encuentra contenido en los instrumentos internacionales de derechos humanos, sino que también forman parte de los compromisos del Estado desde la firma de los acuerdos de paz en Guatemala.
A struggle in which they have demanded that the state of Guatemala recognize and respect the right to freedom of expression for indigenous peoples, a right that is not only contained in international human rights instruments, but also forms part of the state's commitments during the signing of the peace accords in Guatemala.
Asimismo, es importante mencionar que la sentencia no hubiera sido posible sin el trabajo conjunto que hemos realizado con otras organizaciones de derechos humanos como Cultural Survival.
It is also important to mention that this judgment will not have been possible without the joint work that we have done with other human rights organizations such as Cultural Survival,
así como con el equipo jurídico que hemos podido consolidar con la Clínica Legal de Derechos Humanos de Pueblos Indígenas de la Universidad de Suffolk.
as well as the legal team that we have been able to consolidate with the Indigenous Peoples Human Rights Legal Clinic at Suffolk University.
En donde la experiencia y conocimientos de las abogadas Nicole Friedrichs y Amy Van Sil Chavarro fueron importantes para sostener este proceso de litigio que duró más de 1 década.
Where the experience and knowledge of attorneys Nicole Friedrich and Amy Van Sil Chavarro were important to sustain the litigation process that lasted more than a decade.
Asimismo, no quisiera dejar de mencionar y agradecer a las y los estudiantes que han formado parte de este equipo jurídico en las diferentes etapas del caso.
Likewise, I will not fail to mention and thank the students who have been part of this legal team in the different stages of the case.
La sentencia que nos tiene el día de hoy presentes en este recinto tampoco hubiera sido posible sin el apoyo que las y los diversos relatores especiales de libertad de expresión de la Comisión Interamericana de Derechos Humanos brindaron a los pueblos indígenas en Guatemala.
The judgment that has us here today will not have been possible without the support that the various special reporters for freedom of expression of the Inter-American Commission on Human Rights provided to the indigenous peoples in Guatemala.
Ya que en el marco de su mandato emitieron y reiteraron recomendaciones al Estado de Guatemala ante las evidentes violaciones a los derechos humanos que sufrían las y los comunicadores de pueblos indígenas al ser encarcelados o al ser allanadas las radios comunitarias.
Since, within the framework of their mandate, they issue and reiterated recommendations to the state of Guatemala in view of the evident violations of human rights suffered by the indigenous people's communicators when they were in prison or when their community radio stations were raided.
En este sentido, la atención que el Sistema Interamericano de Derechos Humanos brindó a los pueblos indígenas representó para ellos un espacio en donde no solo fueron escuchadas sus demandas, sino que además con la sentencia se reconocía que sus demandas eran legítimas.
In this sense, the attention that the Inter-American human rights system provided to the indigenous peoples represented for them a space in which not only were their demands heard, but also, with the judgment, it was recognized that the demands were legitimate.
Por este motivo, este premio viene a fortalecer el trabajo que hemos realizado de manera conjunta con los pueblos indígenas en Guatemala y asimismo viene a remarcar la importancia que tiene este caso para ampliar la protección del derecho de libertad de expresión.
For this reason, this award strengthens the work that we have done jointly with indigenous peoples in Guatemala and also highlights the importance of this case to expand the protection of the right to freedom of expression.
Sobre todo porque actualmente esta sentencia se encuentra en etapa de cumplimiento y nos hemos visto con obstáculos en donde los funcionarios estatales siguen resistiéndose a cumplir con la sentencia.
Especially because this judgment is currently in the compliance stage and we have encountered obstacles in which state officials continue to resist complying with the judgment.
Sabemos que este caso trasciende de las fronteras de nuestro país y es por eso que también agradecemos el apoyo que otras organizaciones de derechos humanos de Latinoamérica han brindado al caso en momentos puntuales.
We know that this case transcends the borders of our country and that is why we are also grateful for the support that other human rights organizations in Latin America have given to the case at specific moments.
No quisiera dejar de agradecer a las 4 comunidades víctimas, el pueblo maya Kaqchikel de Sumpango, pueblo mayamam de Todos Santos Cuchumatán, pueblo mayamam de Cajolá y al pueblo maya achí de San Miguel Chicaj por permitirnos acompañarles en este camino de búsqueda de justicia.
I would like to thank the 4 victim communities, the Maya Kaqchikel people of Sumpango, the Mayamam people of Todos Santos Cuchumatán, the Mayaman people of Cajola, and the Mayan Achi people of San Miguel Chica for allowing us to accompany them on this path of seeking justice.
Asimismo, reconocer que existen otras comunidades y pueblos indígenas quienes también han formado parte de este proceso y a quienes también agradecemos la confianza que han depositado en nosotros.
Likewise, we would like to recognize that there are other communities and indigenous peoples who have also been part of this process and to whom we also thank for the trust they have placed in us.
Por último, agradecemos a esta iniciativa por premiar los esfuerzos que diversas organizaciones de derechos humanos, abogadas y abogados, así como comunidades y pueblos indígenas han realizado para la defensa y promoción de un derecho tan importante como lo es la libertad de expresión.
Finally, we would like to thank this initiative for rewarding the efforts that various human rights organizations, lawyers, communities, and indigenous peoples have made to defend and promote such an important right as freedom of expression.
Gracias.
Thank you.